I'm a professor right now at Notre Dame Law School. I teach structures of the Constitution, law and religion, and First Amendment, and my scholarship focuses on rights of especially minority groups or minority beliefs at the intersection of freedom of speech and religious liberty. And this particular paper looks at some questions in that genre from a more historical lens. So it's great to get to be here with you all today. I recognize some of your names, and at least being together online if we can't be together in person. So a lot has been written about a question, which is when the First Amendment requires the judiciary to offer exemptions from laws in order to protect religious conduct. What an exemption often looks like is that there might be a broadly applicable law, say a law requiring people to have a state motto on their license plate. And so the question is, what happens if someone has a conscientious or religious objection to doing that? How should we handle those sorts of situations? Should we just wait for the legislature to create an exemption to protect that sort of religious belief? Or can the judiciary come in and say that for this particular person, in this particular instance, the government doesn't have a good enough justification to trample on someone's religious beliefs and to require them to comply? That is what the Supreme Court said, for example, in a case called Woolley versus Maynard that was dealing with that sort of license plate scenario. But what a lot of scholars have debated about is, what does history tell us about this constitutional question and the role of the judiciary in protecting religious exercise and religious rights? Some scholars have argued that the religious exercise clause or the free exercise clause was understood to include broad protections for religious liberty, consistent with the ability of individuals to practice their religion, even when those religious beliefs sometimes butted up against other broadly applicable laws, like that license plate motto example I was telling you about. Other scholars have argued that the free exercise clause was understood much more narrowly, only to include freedom from overt government targeting or discrimination. And so as long as a law like that hadn't been written in order to persecute certain minority groups, then there's no problem. The free exercise clause has nothing to say about the incidental burdens, even if they're significant, that might be placed on those groups. So this scholarly discussion, I think, has been both really interesting and important. But one assumption that has been shared on both sides is the idea that it would have been a significant change in the law and in judicial practice for courts to create judicial exemptions from any sorts of laws or statutes to protect conduct. Another way of thinking about this is that there is a lot of broad agreement that at the founding period, there were lots of protections, including religious exemption protections for religious rights. For example, we exempted Quakers from having to serve in the military because they had conscientious objections to participating in warfare and were a very peaceful religious group of people. And so we created exemptions that allowed them to opt out of military service. Similarly, for other minority religious groups during the founding period, we created exemptions so that they didn't have to swear oaths when they were in court, because some of them view that as against their conscience. So there was a lot of historical practice of granting broad protections when religious beliefs sometimes butted up with generally applicable laws. But the debate is about what the role of judges should be in resolving those sorts of conflicts. And some scholars are arguing we should just leave that up to the legislature. There was no understanding that the judiciary would create exemptions or carve-outs from laws. And on the other side, scholars have argued that if the judiciary did start doing that, it would have been a big change in the law. They have just sort of argued that that big change happened. So there's agreement that there would have been a significant change if the judiciary started doing that. The article I'm discussing today challenges that conventional wisdom and is trying to bring to light an important consideration that has been overlooked. A closer look at the historical evidence reveals that judicially created exemptions are neither new nor extraordinary, just the opposite. Under a widely accepted doctrine known as the equity of the statute, courts exempted conduct from a wide variety of laws that swept too broadly. And they did so in order to protect a wide range of individual rights and interests. This was a practice that was embraced both in England and America leading up to and during the founding period. A clearer understanding of the judiciary's practice for granting exemptions matters for understanding and gaining a clear understanding of the historical meaning of the Free Exercise Clause. There's particular urgency for this question right now because the Supreme Court granted certiorari on a case, Fulton v. City of Philadelphia, where they will hear argument on that case this fall in November. And one of the questions presented in that case asks the court to revisit its approach to the judiciary offering religious exemptions. In the 1940s to the 1980s, the Supreme Court held that the First Amendment required courts to grant judicially created exemptions in certain contexts and to protect religious conduct. Then in Justice Scalia's famous 1990 opinion in Employment Division versus Smith, the court reversed its approach. And now the court seems poised to potentially change its trajectory yet again. So in this talk today, I'm going to touch on 3 points. First, I'll talk about a history of judges creating exemptions to statutes under the doctrine I mentioned, equity of the statute. I'll explain how this history is relevant to modern constitutional adjudication. Second, I'll discuss some implications of this historical perspective, including with respect to the assumption that some of the assumptions the court relied on in the Employment Division versus Smith case. I'll then briefly conclude. So the historical story of religious exemptions, I would submit, is simply part of a larger story about early development of judicial review in judicial constitutional adjudication. By shifting our perspective away from just a siloed focus on religion to a broader historical lens, a myriad of judicially created exemptions from statutes have been hiding in plain sight. Courts created these exemptions in a practice that perhaps dates back to Aristotle, who said, laws being in their nature general cannot decide rightly in the infinite variety of particular cases. Thus, when an exception to the rule occurs, this exception is admitted in equity. Aristotle talked about how admitting these sorts of exceptions in equity would fix the defect inherent in laws by nature of their universality. Blackstone also is famous for championing this doctrine, explaining that courts accept those circumstances that the legislator would have accepted had he foreseen them. And again, this interpretation method was a norm for courts leading up to and during the founding period. Just as a brief side note, the label for this doctrine, equity of the statute or equitable interpretation, should not be confused with remedies that at the time were specific to courts of equity as opposed to courts of law. The former was a run-of-the-mill statutory interpretation method that was used by all different types of courts. And one method that judges would use in this equitable interpretation genre to determine the most equitable application of the statute involved a reliance on the Mischief Rule. The Mischief Rule would look at the context and the problem that the legislature was focused on and that the law was aimed at solving. Exemptions could be offered from laws by the judiciary when a specific application didn't actually address the mischief that the law was trying to solve and that was related to the law. So in America, judges were relying in part on the legal fiction that the legislature would not have wanted to violate the Constitution. And that's how they justified this sort of equitable interpretation. One example of this type of equitable interpretation comes from the 1813 case of Starr versus Robinson. There, a statute provided that all bond or bonds which have been taken by the sheriff are hereby discharged. So, in other words, if there has been a bond or a bonds that the sheriff has taken against someone and they're a debtor, that's discharged. The debtor doesn't owe money anymore. That's what this statute is saying. So a case was brought by a debtor whose debt had already been assigned to a third-party creditor to collect prior to the statute being passed. The debtor said that this statute was too clear to be construed to exempt his bond. It said that all bond and bonds had been discharged, and so his bond should be discharged. Nevertheless, the court disagreed and concluded that this broad statutory language could not apply to this particular debtor bond, and it exempted it. The court said that if the law had been written so as to explicitly apply to discharge that sort of bond, it could not be permitted to operate, as it would have been a palpable violation of the Constitution, interfering with freedom to contract. Rather than declaring the law facially void, the court decided to avoid doing that, instead construed it in a way that would avoid implying the legislature violated the Constitution, either out of ignorance or design, but would still constrain legislative power and prevent what the court was viewing as an unconstitutional application. Keith Whittington is a scholar who has pointed to some of these early equitable interpretation cases as serving as historical analogs for what is now modern as-applied constitutional challenges. A successful as-applied constitutional challenge today essentially leads to the judiciary just refusing to enforce certain discrete aspects of some applications of laws that would result in an unconstitutional outcome. But a facial challenge, standing in contrast to that, is when the judiciary today would say, this particular law, these words of the law, have no valid application. In other words, under as-applied challenges, modern courts are creating exemptions from statutes. Two key moves appear to have occurred over time as judges evolved from engaging in explicit equitable adjudication to, among other things, as-applied constitutional adjudication. First, judges spoke more clearly in terms of conflicts with constitutional requirements, rather than relying on lofty natural law rhetoric or rhetoric about fundamental principles of justice. Second, judges moved away from relying on a legal fiction of legislative intent to justify an unnatural statutory construction, and instead became more candid about the fact that they were reining in certain applications of statutes that would simply be unconstitutional and therefore would not be allowed. So what are the implications of this broader judicial history when it comes to the more specific context of religious exemptions? Importantly, I think that this historical perspective undercuts at least three of the assumptions that are relied on by the court in Smith, and also that some subsequent scholars have relied on historically in order to defend Smith. First, contrary to Justice Scalia's assertion, the idea of the judiciary providing exemptions from generally applicable laws was not an anomaly. He called it a constitutional anomaly. But this wouldn't have been anomalous at all during the founding time period. To the contrary, courts had no problem announcing exemptions to old, broadly phrased laws where application of those laws contradicted other higher forms of fundamental law. Opponents of religious exemptions can't rely on the unprecedented nature of judicial exemptions as evidence that religious exercise was only a narrow protection against the government. In other words, they can't argue that this sort of remedy was outside the scope of what was properly understood to be within the realm of judicial power. Second, citing to Professor Philip Hamburger, Justice Scalia argued that generally applicable laws should not be subject to judicial scrutiny. And this is in part because religious liberty didn't include the right to do that which was lawfully prohibited. And if a law was generally applicable, it was lawfully prohibiting things. This circular reasoning overlooks an important fact, that under things like equitable interpretation of statutes, judges were determining that many applications of a statute would not themselves be lawful, thus requiring an exemption. Courts refusing to apply statutes in light of these constitutional limitations followed from recognition that constitutional limitations were themselves part of the law, that baseline legal norm. Historically, judges also viewed broad and generally applicable language in statutes skeptically as a mandate that may not have been very carefully written by the legislature, and that when it butted up against constitutional rights, needed to be reined in through equitable exemptions to prevent problematic applications. Finally, Justice Scalia argued that a society that allowed judicial religious exemptions would be courting anarchy, and it would be devastating for the rule of law. The founding era courts provided equitable exemptions precisely because they understood that remedy to be more respectful than declaring a law facially void. That preference for constitutional adjudication notably continues today. The modern Supreme Court has described as applied challenges as a modest remedy, the basic building block of constitutional adjudication, and a default. In contrast, facial challenges today are described as a disfavored constitutional remedy, a more drastic tool that courts engage in. And outside of the religious context, Justice Scalia has actually written in favor as applied challenges being a default over facial challenges. So to be sure, the fact that Smith relies on some assumptions that have no basis in history doesn't go the full distance of establishing that religious exemptions are required by the First Amendment, or that Smith should be overruled. To be fair, even some defenders of Smith acknowledge that the case relies on faulty analysis for a number of reasons. So a full treatment of all of the historical evidence about religious exemptions is beyond the scope of this article. But an understanding of the role equitable interpretation plays for the judicial exemptions is important to recognize the potential judicial role in this debate, and adds at least some historical support for one important reason. And that is that the Mischief Rule that I talked about earlier was an equitable form of analysis that has some resemblance to modern strict scrutiny analysis. Courts, in applying the Mischief Rule, focused again on the problem that the legislature was trying to solve when it crafted the law, and then they might employ the Mischief Rule to exempt applications of laws that didn't actually help the government address its goal or the mischief it was trying to solve. So similarly, under modern strict scrutiny, a court considers what particular government interest is animating enforcement of the law. And then it identifies whether or not particular application of law in a certain context is actually going to advance that interest. There's one example that Blackstone provides of the Mischief Rule that sort of shows how this is similar in some ways to looking at the substantial advancement prong of strict scrutiny. He described a law that stated, whoever drew blood in the streets should be punished with utmost severity. But then Blackstone asks whether that law could punish a surgeon who opened the vein of a person who fell down in the street with a medical issue. And Blackstone was saying, basically, of course, this law wouldn't be able to be applied to punish a surgeon who is trying to help someone. That application would do nothing to advance the mischief that the law was really aimed at, which was to prohibit violent bloodshed in the street. This sort of mischief analysis, which again resembles strict scrutiny analysis in important respects, also is similar to the type of analysis some of the early courts employed when they provided religious exemptions. So in two of the earliest cases we have dealing with requests for religious exemptions, it was a priest requesting to receive an exemption from subpoena requirements so that that priest could keep certain confessionals, confidential information that had been divulged during confessional as something private and not something that he was going to testify about in court. Both a New York court and a Virginia court determined that application of these sorts of subpoena rules in general they were aimed at reducing crime and bringing truth to the court bodies. But they concluded that applying this rule to this particular case, to this priest, wouldn't actually help the government combat its mischief of reducing crime. If anything, encouraging criminals to go do things like confess might actually also be helpful to crime. And putting this priest in a situation where he was forced between a rock and a hard spot, and either to breach one of his most important priestly functions or suffer severe penalties, wasn't going to do anything to help the government. So they offered a judicially created religious exemption. This historical perspective contradicts the position asserted by some scholars that this strict scrutiny analysis we employ now has no basis in history, and that it would have been sort of preposterous to think of courts engaging in this type of analysis. So in conclusion, this article is questioning this conventional wisdom regarding judicial exemptions and looking to the question from a broader perspective. When one views judicial exemptions for religion through the broader lens of equitable interpretation, one finds historical evidence of judicially created exemptions across the board that have been hiding in plain sight. The judiciary's ability to modify statutes to cohere with higher law principles like constitutional rights was widely accepted in the early republic. Though the judiciary wasn't necessarily using modern language of exemptions, that was functionally what judges were doing on a large scale and throughout the country across a host of personal rights. This historical evidence demonstrates that it would have been an appropriate judicial role, it would have been understood as an appropriate judicial role for courts to protect religious exercise and to carve out exemptions from laws in order to make sure that that robust protection for religious exercise continued. There may be other reasons to debate the historical support for religious exercise, but one of the most prominent ones, which has been this concern about if exemptions were part of the judicial role, isn't a critique that historically I think is a sound one to rely on. And in fact, these courts were engaging in things that looked an awful lot like the type of strict scrutiny analysis courts engage in now. So this approach may have more historical support than the court's current approach under Employment Division versus Smith. And from there, I'm happy to take questions.